So welcome everyone. The webinar today is about IP and how proper management of IP can help companies drive up their value. We're living right now in a very, very rapidly changing world, and these changes are happening at an ever accelerating pace. And with that, innovation is often needed, and let's say innovation is needed to face the challenges that and opportunities that are presented by this change. As we all know, innovation often happens when there is creativity, either as a result of someone's personal intellectual efforts or intellectual efforts of let's say of a group as a result of a collaborative effort. And more often than not, such efforts, either by individuals or groups, result in intellectual property. Managing IPs is a challenge. So companies, and especially those in the startup sector who are driving innovation, they are also growing at that ever increasing and incredible speeds. So while today the focus is more on the startup side, the IP issues are very similar also, and the challenges that are faced from the IP side are very similar also to mature and operating companies. For example, let's imagine that you are a successful company producing, for example, chocolates, and you have a unique product line with some unique packaging design for you. And you have been on the market for maybe 10 plus years already, and your marketing department says that, okay, we need to tweak this packaging a little. The funny thing is that unless that company had been diligent at the time when this packaging line was designed, maybe it will not be easy to introduce these new tweaks. So maybe sometimes from legal point of view, it's only a question about a few words in the IP transfer or licensing agreements, but these words often have quite a heavy weight. So with that introduction, today on the agenda we have three of our colleagues talking about these topics. So first off, we will have Robin, who will be giving us a short overview of M&A transactions. Then we will have Olivia Kranich to talk about intellectual property as an asset class. And then lastly, Oliver Kuusk, who will talk about open source components. Now, we will also take questions. So I think the easiest would be to use the chat function. And then in the interest of timing, I will maybe cut off the questions if you have any during the presentations, but we will have some time at the end to have Q&A as well. So with that, I will give the word to Robin and ask you to take it from here. Thanks.
Great. Thanks, Mihkel. Oh, this is a nice reminder that I need to get my picture changed. It's been 3 years. Okay, nice. So as Mihkel briefly introduced, my name is Robin, and I'm a senior associate in our firm's corporate and M&A department, which means that whenever M&A transactions, or in particular startup transactions, come knocking at our door, then Mihkel's team and ours work very closely together, and in particular in IP matters, which is the topic of today's webinar. I think we can jump to the next one, yeah. So taking into account the topic of today's webinar, I thought that I will not be doing a deep dive into the various types of M&A transactions or even the various types of startup transactions, albeit mostly they revolve around fundraising, whether issuing debt or equity, because both of those topics can be subjects of separate and long and extensive webinars of themselves. But I did think that it's to focus this on IP and from an M&A side with a startup flavor. So the reason being is that startups in particular, by their nature, they are more often than not, they are involved in, creating something, inventing something, coming up with a novel approach to do things or to change how things have been done previously. And all those aspects of innovation, all those, efforts of development, of creation, they involve the creation of IP, which makes IP, especially in the startup sector, so crucial, both to founders, the companies themselves, but to employees who are potential option holders, and investors from whom these investments in terms of fundraising are coming from. So that is why they play such a big role and deserve some particular attention. So how IP comes into play in terms of M&A transactions is mostly through the sort of medium of due diligence. And to those of you who have had the pleasure on being on the receiving end of a due diligence exercise will know that it begins with the arrival of this mammoth questionnaire, which features a whole array of topics. But one sort of crucial mainstay of those topics is IP. I've yet to see a questionnaire that doesn't have that particular section in it. And for startups, the some of the other sections, for example, financing or taxes, may not be as relevant as IP because of the reasons I listed previously. So when these sort of request lists for information come in from investors' councils, they go into very sort of detail as to what kind of information the investors are looking for in terms of IP, and it may seem a bit daunting at first, which is before jumping into what it is exactly that we usually look for, and as lawyers, and the conclusions that we draw from the answers that we get. I would perhaps offer one practical tip. In my experience, it's always been a good sort of head start and helps to get the fundraising process off to a running start if the due diligence process commences very smoothly. So what that is helped by is if the company itself, when it gets this sort of request list and it already has it compiled and arranged its internal documentation in such a way as to immediately provide to the investors. So that sort of speeds up the process, which everyone is interested in, because the due diligence can be a sort of a logistical headache. And to do that, one tip would be to perhaps use some due diligence questionnaires that you've got previously, or if you haven't yet, then just there's a model checklist available at the Startup Estonia website, which can be of help. They can get more extensive than what that model document looks like, but it's a start. So let's, I think, move on. So whenever we start these due diligence affairs, the main aim, or at least the first aim, is to understand what it is that the company does, right? What does it sell? What services does it provide? To whom does it provide these services or sell these products to? Because in addition to directly asking what IP do you have, that enables us to understand indeed what IP the company has, which in turn helps us to sort of put that existing IP into a legal framework context, in the sense that, okay, it has this kind of IP, it has some kind of name recognition, perhaps there's a trademark opportunity here. Has it applied for that? If not, why not? It enables us to assess the array of legal methods to protect that IP that the company may have available to it. And of course, in terms of IP, its creation is something that is always involves a creator, in the sense it's not something that you just come across in the wild. So it's always crucial for us to understand who has been involved in the creation of this IP, and has the company taken the necessary legal steps to procure that all IP has been assigned to it, or to the extent that it cannot be assigned, licensed to it, so that it's free to commercialize its IP, that it isn't hindered in doing so by someone that they previously worked with. And of course, if what else does the company's IP rely on? Does it use some third-party proprietary software? Is it complying with the terms of that software? Does it include open source components? All of which, mind you, this is a very brief overview of what the IP questionnaires look like, and these topics will be sort of subject to more in-depth analysis by Olivia and Oliver, but essentially that's it in a nutshell. And if we can just move on. So we ask an array of questions, both on IP topics and various other kinds of aspects. But so what do we do with the answers that we get? We usually end up with findings, which I have sort of listed the types of findings or the recommendations from those findings here. So, for example, if we have a situation where the company has had employees or service providers who have not sort of duly licensed their, rights in software or inalienable authors' moral rights to the company, that exposes the company to significant risk because those persons can, make some mischief and sort of hinder the company from using its IP. So that's something that investors will want to see fixed before, consummating the transaction, meaning that fixing those issues will be conditions precedent to, the money coming in. Another type of finding that we usually end up with is that if we ask that, is the company in breach of its licensing terms, or is anyone breaching the company's own licensing terms? Usually the answer is no, not that we are aware of. And to sort of make it a point, then that those things end up as warranties, meaning that essentially confirmations or promises that the company and the founders give to investors saying that something is really as the warranty states it is. If the opposite turns out to be true, there are legal remedies that usually follow, including but not limited to damages claims. Specific indemnities there are a bit rarer in startup transactions, but they are usually used if we already see that something is really wrong, but the risks have not yet materialized. And finally, because IP involves a lot of efforts which may not be as immediately perhaps addressed. For example, we see that the company has obtained some name recognition, or its products have. So there's an avenue perhaps to explore trademark registration, which is a time-consuming process, and it's not necessarily something that you need to deal with during the transaction phase. So that usually ends up as a condition subsequent. So following the transaction, you will start to assess, which markets you want protection in, and in what areas of products or services, and as well as, if the company has a sort of intensive process of creating something, it's worth investigating whether something qualifies as an invention and perhaps qualifies for patentability or a utility model. Now, this has been a very breakneck run through of IP, of the role that IP plays in M&A transactions, and I will be handing over to Olivia and Oliver. Olivia first to take a sort of more in-depth look at these, but from my side, I think that's where I draw the line.
Thank you, Robin. We didn't have any questions in the chat. I know that you will be leaving shortly, but since anyone didn't seem to have any questions, I think we can move on towards Olivia's presentations. Thank you.
Good morning, everyone. As Mihkel said, my name is Olivia, and I'm senior associate here at Sorainen, and I'm mostly dealing or focusing on intellectual property matters. And maybe we can proceed with going more into detail of what Robin already mentioned. So it follows from what Robin said that the value of intellectual property should not be underestimated. In many cases, a company's intellectual property may be its most valuable asset. For example, trademarks like Google, Amazon, Microsoft, and Apple are worth billions of dollars. So in light of any potential M&A transactions, it is important for both parties to understand what the target's intellectual property portfolio consists of. In wide scale, intellectual property assets can be divided into two spectrums. So firstly, there are assets that can be protected with registrations. These are trademarks, business names, domain names, patents, utility models, geographic indications, and industrial designs. Conditionally, business secrets could also be listed under the first spectrum because of the need to identify what your business secret is and also to keep it truly a secret. Secondly, there are copyrights which cannot be protected with registrations and which you acquire automatically from the moment of creating a work subject to copyright protection. To go more into detail, a trademark is a designation that differentiates your product or service from products or services of others. It's important to keep in mind that a registered trademark gives protection only in the territory of and with regard to goods and services for which it is registered. For example, a few years back, political party Eesti 200 applied for the registration of its name as a trademark for various goods and services. The application was opposed based on an earlier logo format trademark Eesti 200, which was registered only with regard to a specific service, organizing and conducting symposiums. So after a lengthy dispute of almost 3 years, the Estonian Intellectual Property Board of Appeal found the opposition to be not grounded because the political party's goods and services were different from the opponent's services. This means that the owner of the earlier trademark Eesti 200 is not able to prohibit the use of Eesti 200 by the political party. So it's very, very important to keep in mind that you protect your trademark for all goods and services. A business name is a name entered in the commercial register under which an undertaking operates. Before agreeing to register a business name, commercial register normally checks whether there are any earlier conflicting trademark rights. And vice versa, in some cases, registered business name could also become obstacles for trademark registration. Domain name is an address used to reach a particular website. Domain names consisting of general indications such as insurance or casino or hotels tend to be more valuable, but it's definitely more valuable to have your own trademark used or registered as a domain name as well. Patents and utility models are both used for protecting inventions, whereas the requirements applicable to patents are a bit stricter than requirements applicable to utility models. In any case, both patents and utility models have to be new, and invention, what is disclosed already publicly, is not new. So the most common issue we see in practice is that companies do not consider the possibility to protect their inventions with patents or utility models, and they disclose some information about their invention publicly. Unfortunately, this means a loss of opportunity. And once you have disclosed the invention, it's very difficult, or if not impossible, to get it registered as a patent or utility model. A geographical indication is more of a rare intellectual property asset. It shows that the goods or services originate from a particular area, and the characteristics of the goods or services are related to this area. For example, in Estonia, Värska water is protected or Värska is protected for mineral water originating from Värska. Industrial designs are a 2- or 3-dimensional appearance of a product. So these could be logos, or it could be also a shape of a bottle or shape of some other product. But industrial designs could also be registered. Industrial designs could also be used to protect the designs of a website or a mobile application. Business secret is what it basically says it is. It's a commercially valuable information. A classic example of valuable business secret could be the recipe of Coca-Cola. For intellectual property objects, which can be protected with registration, the main questions that we as legal advisors seek to answer during legal due diligence checks are the following. Are registrations in place or applications filed for everything that needs to be protected with registrations? More specifically, are all trademarks that the target company is using already registered, or are the applications filed? Are the trademarks registered in all relevant territories and for all relevant goods and services? Does the company hold registrations for most popular top-level domains, for example, .com and .eu? So Different IP assets are material for different businesses. Trademarks may be key assets for a retail business, whereas patents are important in pharmaceutical industry. Focus of the due diligence depends also on the type of transaction. In case of merger where the acquiring company is not interested in using the target's trademarks, for example, because it plans to use only its own trademark portfolio in later stages, so it will not focus on whether the trademarks are valid and already registered. Secondly, are the registration in question valid? Trademarks need to be renewed after every 10 years. Patents can be valid in total of up to 20 years, but require payment of yearly fees. So the aim here is to make sure that the rights to relevant assets are still valid and the yearly payments are duly paid. Do any registrations need to be renewed during or shortly after the transaction? So if yes, it might be necessary to agree on who will take care of the renewal and pay applicable costs. It could be a material mistake to just slip the renewal date when it happens to be during the transaction, so nobody knows who will take care of the renewal or who is obligated to take care of the renewal. In whose names are the registrations? Are the registrations held by the company as a legal person or maybe by a certain founder or employee as a natural person? Is the target company current right holder? Are there any gaps in the chain of title? Sometimes a previous assignment, merger, or name change has not been recorded in the registers. So it might be difficult to record the later changes in the registers when the last right holder, legal person, has already been deleted as a company. And lastly, are there any ongoing disputes? Ongoing opposition, cancellation, or invalidation proceedings are potential threat to registrations being valid. This risk definitely translates into valuation. Invalid registrations have no value for potential buyers or investors. Some time to correct, and it could also become a problem when the natural person who has registered the domain name decides to leave the company. So he or she could just refuse to transfer the domain name to the company, or only agree to do it against a hefty compensation. So relevant top-level domain names are not registered or belong to third parties. Once again, domain names are registered on first-come, first-served basis. Costs for the initial registration of a domain name are quite low. We're talking about 10 years per year for example, for a .ee domain name. So if you operate under a specific domain name, for example, .com or .eu, but you target also customers in Estonia, Latvia, or Lithuania, it is wise to also secure registrations for .ee or .lv or .lt domain names. The issue with domain names is that when someone beats you to it, registers the domain name that you wish to use, it might be very difficult and costly to get these people to give the registration up. Actually, there's a group of people that are kind of cyber squatting and trying to register good domain names in advance and then trying to sell them for a specific amount of gain. One of the more recent topics maybe is social media accounts. In a dispute over ownership rights of a Facebook page, Estonian courts recently concluded that rights to Facebook pages can only be managed by natural persons, not by legal entities. So basically, a business account can be opened so that a natural person uses its own personal account and then use this to open a business account. And this stems from the terms and conditions of Facebook, and the situation is same for most social media platforms. And now if a business account or page is opened and run by a natural person, that person has the access and control over the account. If no safeguards are in place, for example, in a format of contract, you not have regulated in employment contract or other documentation, the person who runs the account can at any time cut your access to it. And if you think social media accounts are worthless, then I would recommend to think again. Social media accounts should be treated as versions of the company's website, and depending on the type of business, they might be highly valuable assets. Now moving on to the second part of the intellectual property assets, copyrights. Copyrights protect any original results in the literary, artistic, or scientific field, which is expressed in an objective form and can be perceived and reproduced in this form either directly or by means of technical devices. Automatically, copyrights belong to the actual authors of the work, so the natural persons. As an exemption, Estonian law prescribed that when an employee working under an employment contract creates a work subject to copyright within the execution of his or her employment duties, economic rights to such works are transferred to the employer. And this happens automatically if you have an employment contract. If the work in question is a computer program or database, the economic rights remain with the employee, but the employer gets an exclusive license to exercise such rights. So we already concluded from that the copyrights consist of actually two sets of rights. There's author's economic rights and moral rights. Economic rights allow the rights holder to derive financial reward from the use of works by other. You may allow the work to be used by others to reproduce it, and you will get monetary gain from it. Moral rights in turn allow the author to take certain actions to preserve and protect their link with the work. And under Estonian law, one of the moral rights is also the right to make or permit others to make changes to the work. This means if, for example, economic rights of an employee are transferred to the employer under the employment contract, but nothing has been said about moral rights, then the moral rights remain with the employee, and the employee can prohibit the work to be further amended and actually demand that the work is taken back. For this reason, it's very important that all agreements with employees and subcontractors and everyone that creates something for the company which could be protected with copyrights include proper regulation on both economic and moral rights. Furthermore, the Estonian law prescribes that moral rights are inseparable from the author and therefore cannot be assigned. So when we're talking about economic rights, these can be assigned. Employee assigns them to the employer, and the employer is now holder of the economic rights. But for moral rights, these are inseparable and can't be assigned. And this means that they can only be licensed. You can give license to someone to use or exercise your moral rights. A peculiarity of the Estonian law is that license agreements concluded for an unspecified term can be terminated with 1 year's notice. So meaning that depending on the circumstances, a license agreement for authors' moral rights should be for a specified term. So this could be, for example, for 99 years or for the entire duration of the legal protection of the rights in question. In light of the aforesaid, the main questions that we as legal advisors seek to answer in legal due diligence checks are the following. Who has participated in the development of material intellectual property assets? This includes founders, employees, subcontractors, and both current and former. It is not that rare that the target company is required to reconnect with former employees to get them to sign proper IP assignment and licensing agreements. Are appropriate agreements in place with relevant persons? Think of employment contracts, service agreements, and so on. Again, the target company may be required to conclude agreements posteriorly. Is the regulation on intellectual property rights established sufficiently? In short, all economic rights need to be assigned, and for moral rights, an exclusive worldwide license need to be granted for a specified term. Depending on the circumstances, you can agree on different setups, but this is the most safest way to ensure that all rights are appropriately assigned and licensed. And lastly, can intellectual property rights be further assigned and licensed? So agreements on assignment and licensing of copyright should also establish the right to further assign the economic rights and sublicense the moral rights. So the target company can give them rights to the purchaser. Most common issues relating to copyrights we see in practice are that no agreements are in place with regard to copyrights, no separate regulation is established on the assignment and licensing of copyrights in relation to computer programs. This is a specific topic for startup companies. No distinction is made between economic and moral copyrights, and moral rights are licensed for an unspecified term. An example case to illustrate the importance of intellectual property relates to our very own Skype. When eBay bought Skype, critical peer-to-peer technology called Global Index, which was actually developed by Skype's founders, Fries and Sandstrom, remained with letters in the separate company. So they had a separate company for which they created this technology Global Index. And Fries and Sandstrom refused to sell or license intellectual property rights to this Global Index to eBay. So eBay therefore purchased Skype subject to a license agreement for the relevant technology between Skype and the founders' company. So there was a license agreement in place between Skype and the founders. And now when eBay bought Skype, eBay would get the gain of this license agreement and use it for its business. This license, however, granted Skype the right to use an executable-only form of the code known as the object code, so which cannot be edited. So Skype did not have any rights to the license of the source code. So this arrangement worked as long as Fries and Sandstrom remained with Skype. And after their departure, the founders actually challenged eBay's use of the Global Index technology and claimed that Skype obtained unauthorized versions of the source code and breached the terms of its licensing agreement by continuing to modify and create derivatives of the source code. All this resulted in a big mess of disputes, which could have been avoided if eBay would have been more careful in determining intellectual property assets material to Skype's business and by ensuring that they form a part of the deal. So it seems it's clear from here that if you don't think ahead, you might buy something, invest into something, and later discover that it's actually not worth the money you paid for it because you can't use it. So this is the importance of intellectual property assets, and I truly recommend to consider them from both sides. If you're an investor or trying to buy something from the market, it's good to know what the target's assets consist of. But from your own side also, if you are thinking of trying to get investments, it's good to have everything in place, everything identified. You know what your intellectual property assets are, what they're worth, and what are you willing to give up for what price. So thank you. This is from my side, and if you have any questions, then I'm more than happy to answer.
Thank you, Olivia. So we don't have any additional questions in the chat at this point, but upon registration, there was one question. Someone asked that what would be the best setup to ensure that intellectual property rights are transferred from employees to companies?
So I would say that the law prescribes that if you have an employment contract in place, then the economic rights will be transferred automatically, except for rights relating to computer programs and databases. But my recommendation would be to have a separate regulation in the employment contract regulating the intellectual property matters. And the safest way would be to agree that all economic rights to any objects of copyrights are actually assigned, and all moral rights are licensed, and the license should be exclusive, and the license should be worldwide, and it should be also for a specified term. So moral rights of authors actually are valid, or all copyrights of authors are valid 17 years after the author's death. So it's good to have the license valid for the entire duration of the legal protections of the rights in question.
Right, thank you. And with that, we'll give the word to Oliver, please.
Thank you, Mihkel, and good morning, everyone. I'm Oliver. I'm an associate at Sorainen, and I mostly deal with tech and IP matters. And for me, the most interesting cases are where tech and IP converge, and naturally, that's where software IP protection comes into play. So I will be briefly talking about the use of open source components and why they are important. So much of today's software includes these little open source components. These are like little building blocks that are used they're made available to everyone, to developers who can copy them, modify them, share them, incorporate them into another product, and then distribute this product. So to give you an idea of how many open source components there are out there, you can go to your phone's settings. This is my phone settings, and you can scroll and look at all these licenses. For me, the list is just never ending. There's an immense amount of open source components in almost every software product, and there are some restrictions that come with them. So that's why it's very important to know the restrictions and also the rights and obligations that come with them. So let's move on to these open source components. Next slide, please. So in the EU and in Estonia, the code which makes up a computer program, this is protected under copyright. And when you're using this little building block or the component, you're actually using someone else's exclusive copyright. And your right to do this comes from this license that is applicable to this component. And this is the open source software license. In very broad terms, there's two categories of licenses. Firstly, we have permissive licenses. These licenses, they give you the most freedom. They give you the freedom to copy, modify, distribute, sell the product, and there is no need to open your product to the open source community. On the other hand, there are also copyleft licenses, and copyleft means that the same rights described in the license must also be preserved in all of the consecutive works that you have created from this component. So this generally means that if you take a component with a copyleft license and you put it within your own product, then you have to license your whole product under this copyleft license. And for this effect, it's also called a viral license. And these are very, very feared licenses. For example, the former CEO of Microsoft, Steve Ballmer, once called these licenses a cancer that attaches itself to everything in an intellectual property sense. So if you're looking to commercialize your software, you definitely need to avoid these kinds of licenses. But what are the main obligations if you use open source software components? What are the main obligations that come with them? Well, firstly, you have to retain the copyright information. This is the information about the author who has created this component. And if you open up your phone and you see the list of legal notices of the third-party components, then you will see all the information about the authors. And secondly, you will also see a license text, because these licenses come with a requirement that you convey the license text with your product. And thirdly, it's often that you need to disclose any changes to the component that you have made. And with permissive licenses, in some cases, you also have to disclose the source code of the component. That is the source code of the modifications that you have made. Now, let's move on. Next slide, please. And let's take a deeper dive into why these copyleft or viral licenses, why are they feared? So a very common copyleft license, probably even the most common, is the GPL license. And let's take an example. Let's say you have a product and you want to add a functionality to it. And there's a specific component that is licensed under the GPL that can add this functionality to it. Maybe you take this component, maybe you modify it a bit, and you incorporate it into your own product. So in essence, you're creating a new and better product with this GPL licensed component. So what happens is that your new product becomes a derivative work of this GPL license component. And this requires you to apply the GPL license to your whole work. So this is the viral effect. And now that your whole product is covered by the GPL license, you have several restrictions to commercializing it. For example, if you distribute your product, if you sell your services, you are in some form required to make your source code available to your clients. And although you can charge your customers for your product, you cannot stop them from selling your product or even giving it away for free. So you can only imagine how difficult it would be to operate a for-profit company under these terms. Now, let's move on. Next slide, please. And let's see, what do you actually need to demonstrate during a transaction, during a legal due diligence project to show that you're on top of your software licensing matters? Firstly, it's likely that you will be asked to provide a copy of your open source software policy. And if you do not have a policy in place, then you should at least be able to describe how you take decisions about open source components in your company. Secondly, on a product by product basis, you should be able to identify all of the open source components in your products. For example, for each component, you should be able to specify what kind of license is applicable to this component. In which manner is this component being used in your product? For example, is it embedded or is it just linked to your product? Then is the component modified in any way, or is it used as is? And lastly, what is the functionality of the component in your software product? And can it be, for example, replaced should it be needed? And in order to do all this, you obviously need to know what's in your code base, and you need to map all of the components in your code base. And often this mapping task is very tedious. It's very good to do this early on, but if you already have a product in place, there are also software composition analysis tools that help you do this. And these are actually also used as part of the technical due diligence that is very often done on software companies during transactions. Now, next slide, please. Let's move on and very briefly recap how to develop your own software policy or strategy. Firstly, you should understand what's the purpose of your project, so you can actually create a licensing strategy around this purpose. So it's very likely that your company is a for-profit company, meaning that you want to protect your source code, you don't want to disclose this, and you want to commercialize this. So this means that you need to avoid these copyleft licenses. And secondly, you need to know what's in your code base. This is the mapping task that I briefly talked about. It's easy to do it early on, but there are also tools that help you map all of the components in your software or your products. And lastly, you should only stick with the licenses that are suited for your project. For example, permissive licenses for commercial proprietary projects, in which case you want to protect your source code, and copyleft licenses for collaborative projects where you actually want to open up your source code to the open source community. So that is very briefly about open source components, and we're actually going to move on, and I'm going to talk about, next slide, please. Very briefly talk about software dependencies, that is being dependent not only on someone else's software, but also any IP rights that come with the software. And after that, also very briefly about commercialization of your own software products. Now, critical software dependencies. So in addition to asking what is your product made of, what are the components in your product, you should also be aware of any other software that is critical to your business. Let's take an example. Let's say there's a plugin, a third-party plugin that you use, and a lot of the components depend on this plugin. So what would happen if you suddenly had no rights to use this? Or you would very likely take a lot of resources, a lot of effort to replace this plugin, especially if you have incorporated this into your product very early on. So in essence, you need to be asking yourself, what kind of third-party software is critical to your business? And do you actually have the necessary IP rights to use this? So this is mostly a matter of having the correct contracts in place and having the sufficient IP licenses in place to use these third-party products. And there's a very specific legal aspect to these contracts, and that comes with a transaction impact. So during transactions, in these contracts, there are very specific chains of control and anti-assignment clauses. And these clauses, they give the other contracting party the right to terminate their agreement with you should there be any change of control in your company, or should you want to assign this contract. So you should definitely look out for these kinds of clauses and avoid them. But okay, if you have some of these clauses, what can you do about it? So if you have these clauses in your contracts, as part of the LDD process, you should be prepared to ask for permissions and approvals from the other contracting parties to actually go forward with this change of control or anti-assignment of the contract. So this is very briefly about software dependencies. And we're going to move on and talk about commercialization of your software. Next slide, please. So when we're talking about commercialization of software, we are in this context talking about what kind of IP rights are you giving away when you're providing your products or services. So this is mostly relevant in business-to-business transactions, but this is actually applicable to all kinds of agreements. It doesn't have to be a license agreement, an IP license or assignment agreement, but it can also be a distribution agreement, reseller agreement, agency agreement, and so forth. So I'm going to go over very briefly about the key rules to keep in mind in these contracts. Firstly, you should always license or provide service for your product. You should never assign or give away your intellectual property. You need to, so to say, keep it close to you. Secondly, you should use non-exclusive and non-transferable licenses. This way, you yourself will retain the exclusive right to actually use and commercialize your product. And thirdly, you should avoid any exclusivity for territories or products. So this way you also retain the most freedom to use your IP. So in conclusion, to recap this, when you're commercializing your products and services, you should always keep in mind to keep the IP close to you. So this way you will have yourself the most freedom to commercialize your products, and this in turn will boost your valuation. This is all from me, and I'll give the word back to you, Mihkel.
Right, thank you, Oliver. Do we have any questions from the audience? Don't see any questions in the chat, unfortunately. Seems that we don't have any questions right now. In that case, I hope that all of those who attended found this webinar to be useful, and really thank you for attending, and see you in our next webinar. Bye.